Now we'll see the law of anticipatory bail from a celebrated judgment of the Supreme Court in Gurbakh Singh Sibia versus State of Punjab, rendered in 1980. In what conditions, in what situations, an order of anticipatory bail should be made? Section 438(1) of the Code lays down a condition which has to be satisfied before anticipatory bail can be granted. What is that condition? The applicant must show that he has reason to believe that he may be arrested for a non-bailable offence. He must be able to show to the court that he has reason to believe that he may be arrested. Now, what is this belief and what is this reason to believe? The court says mere fear is not belief. A belief can be said to be founded on reasonable grounds because there must be reason to believe. So, the belief can be said to be founded on reasonable grounds only if there is something tangible. Grounds on which belief of the applicant is based must be capable of being examined by the court objectively. There must be grounds for the belief, and these grounds should be such which can be examined by the court objectively. And what is the belief which the court will examine? The belief is that the applicant may be arrested for a non-bailable offence. For this belief, there must be grounds. The grounds must be tangible. The grounds must be such which the court can objectively examine. Specific events and facts must be disclosed by the applicant in his application in order to enable the court to judge the reasonableness of his belief. There must be reason to believe, so the belief must be reasonable. The court will examine the reasonableness, and how will the court examine? By considering the specific events and facts which have been disclosed by the applicant in his application. Because this reasonableness of the belief is the sine qua non of the exercise of the power conferred by Section 438. Reasonableness of the belief is sine qua non for the exercise of power conferred by Section 438. We'll now answer another very important question. Is lodging of an FIR necessary for invoking the benefit of Section 438? The answer is no. The court in this case says filing of a first information report is not a condition precedent to the exercise of the power under Section 438. The imminence of a likely arrest founded on a reasonable belief can be shown to exist even if an FIR is not yet filed. So before the filing of the FIR, this benefit or the person concerned can invoke the provisions of Section 438. What happens if the FIR is already filed? Anticipatory bail can be granted even after an FIR is filed, so long as the applicant has not been arrested. Therefore, we can conclude that an anticipatory bail order can be made by a court before the FIR or after the FIR. There must be reasonable ground to believe that the person concerned is likely to be arrested on the accusation of a non-bailable offence. And of course, one very important precondition is that he must not have been already arrested. Once the applicant is arrested, Section 438 has no applicability. Then he has to apply regular bail under the relevant section to the magistrate's court under Section 437, to a court of session or high court under Section 439. 438 will not be applicable once the arrest is made. It is a pre-arrest process. And one more thing which needs to be noted from this order, from this judgment is that a blanket order of anticipatory bail should not generally be passed. The order has to be specific to the accusation. There cannot be a blanket order that this person shall not be arrested by the police. Of course, the language of even a specific order will not be like this. The order will not say that he will not be arrested. The order will say that he will be released on bail in case he is arrested. As I had emphasized earlier, this is not an order to prevent arrest. The arrest will be made. This order will help the accused getting released from the arrest, from the custody of the police. So this is an order for immediate release on bail after the arrest. But the point here is that it will not be a blanket order. It will not be an order like this, that this person shall be immediately released on bail whenever he is arrested. No, the order will be that if this person is arrested on this particular accusation, then he will be released on bail if he is prepared to give bail. The accusation has to be mentioned in the order. The order has to be specific to a particular accusation only.